My name is Roger Nyquist. I'm chair of the Linn County Board of Commissioners. I would at this time like to recognize my fellow county commissioner, John Lindsay. He is here. He's been active on timber-related issues over the years. John, I appreciate your activism and your support this morning. We are here today so that Linn County can announce that we're pursuing a breach of contract class action lawsuit against the state of Oregon on behalf of the Forest Trust Land counties and local districts. The suit seeks more than $1.4 billion in damages. We're here today in part because 75 years ago, many counties transferred lands to the state so the Department of Forestry could manage those lands for the greatest permanent value to the counties and the taxing districts in those counties. And in 1998, the Department of Forestry, through administrative rule, changed the greatest permanent value without the consent of the counties. In the 30s and 40s, this was a contract established, later confirmed as a contract by the Supreme Court in 1985. It's a contract today, and the Department of Forestry has breached that contract. As a county commissioner, one of the things I do is serve on the budget committee and try to pass budgets. Our model, if you will, is that over the last 20 years, our expenses go up about 5% of the year through labor cost increases that are governed by state statute. And due to Measure 47 and 50, our revenue only goes up about 3% a year. So every year for the last 20 years, we've had to reinvent ourselves as 2% less than we were the year prior to that. It's been difficult. And the last thing we need is our partners at the state going backwards in the way of revenue projected to counties through forest lands. For us, this is about a $2 million a year ongoing issue that we feel like we've been deprived of. The other thing I want to say is that this isn't just about a fiscal exercise or a breach of contract. The rural communities in Linn County, the Lyons, the Mill Cities, the Mahamas of the world, their local economies have been devastated. Unemployment rates and poverty have skyrocketed, not in small part because of forestry practices. And for them, it's just not right. It isn't okay, and to this point, we've heard lots of conversation about the plight of rural Oregon by statewide policymakers, but there's been nothing. There's been no one to address the underlying fundamental problem. And that is, we're not managing things in a way that serves their financial interest and stimulates their local economy. Today's announcement in this proposed litigation is an action step to correct that problem and move things in a better direction for rural Linn counties, not just in Oregon, but all over the state. And with that, I turn it over to our counsel, John DiLorenzo.
Thank you, Commissioner Nyquist and Commissioner Lindsay. Appreciate the opportunity. I'm very honored to serve as your counsel in this tremendous undertaking. Thank you all for attending. Thanks for the turnout. It's wonderful, the interest in this case. I'm John DiLorenzo. I'm a partner with the law firm of Davis Wright Tremaine and serve as special counsel to Linn County for the purposes of this lawsuit. I want to take an opportunity to describe your press packet that you have and then walk you through what is called a Rule 32H 30-day notice letter. That is a letter which we are obligated to furnish onto the defendants in the case of a class action. It provides that we must inform the defendants of the theory of the case, inform them of the amount of damages we will be requesting, and provide them an opportunity to cure within 30 days before we can file any litigation. Doesn't mean we have to file litigation in 30 days, but it means we can't file litigation within that 30-day period. You have all been handed a press packet, and you have a press release release, you have the statement from the county commissioners. On the 5th page back, there is a historic timeline which we can respond to later, but it's self-explanatory. And then on pages 6 and 7, they're not labeled, but it's the 6th and 7th page in your packet, are some charts of county-by-county impacts, which I will cover after I go through the 32H letter. And then finally, on the 8th page is the 32H letter. And I'd like to ask that if you go 8 pages into your packet, let's start with that so I can just run through the highlights. I had the opportunity this morning to visit with Mr. Ben Swade, who is the governor's legal counsel, and I provided Ben with courtesy copies of this letter, which is being mailed today. And we had a very good conversation about the contents of the letter. Again, this is a process that must be fulfilled before filing a class action suit. Linn County would serve as the representative party in the class action. The class would consist of the 15 forest trust land counties and also the 100+ local districts who are third-party beneficiaries of the arrangement. The reason these local districts are third-party beneficiaries is because they have entitlements to distributions of whatever the counties receive through the property tax formula. So if someone pays $1 of property tax in Linn County, that money then gets redistributed among the various local districts. And so we believe that these local districts are third-party beneficiaries of that agreement, and they also are members of the class. And who are they? They are schools, they are public safety districts, fire districts, libraries, towns, EMTs, hospitals, you name it. They are, all you have to do is look at your own property tax bill to give you an idea of the breadth of those local districts, all of whom we believe have an entitlement to the money that has been left on the table by virtue of the Department of Forestry's breach of contract. If you turn to page 2 of the letter, you will see that the claim is for $1,435,164,000. That number I will get into in a little bit. It is our view of the value of the damages that the counties and the local districts have incurred by virtue of the breach. Little tiny bit of background, and Commissioner Nyquist went into it, but in the 30s, timberlands were burning up and otherwise abandoned. They were abandoned because it was the Great Depression and the owners couldn't afford to pay the taxes. The counties got the lands back through tax foreclosures, and of course, once they got the lands back, there was no one to pay taxes on them because they were no longer in the tax rolls, plus it was the Depression and the counties didn't have the money to manage them. Because many of these forests were ill-managed and were burning up, Governor Sprague in 1938 proposed an arrangement whereby the counties in their corporate capacity would actually deed the lands to the state. The state would in turn manage the lands, deduct a management fee, and then return to the counties the revenues that were produced by conducting timber operations on the lands. The statutes that were passed in the 40s, in which the counties responded to by deeding their lands away, required that the state manage the lands in accordance with their greatest permanent value. That was a phrase that was undefined for years, from the 1940s until 1998. We believe that at the time, in the 40s, common people would have understood the phrase greatest permanent value to mean the greatest value of your portfolio. Don't cut and run. Maintain them on a sustainable basis, ensure that the counties would continue to receive a flow of revenues over time that would maximize the overall permanent return. In 1986, the Oregon legislature decided to take one of the properties out of production. And you may know this as the Crabtree parcel incident where one of the properties was going to be removed from timber production and was going to be devoted to be a park. The county sued the state. The state took the position that counties can't sue the state, they're the government can't sue the government, and the Supreme Court ruled in Tillamook 1, and now we're at page 3 of the letter, the Supreme Court ruled in Tillamook 1 that first the counties could sue the state because when they deeded over the lands, they did so in their corporate capacity. Number 2, the Supreme Court ruled that the counties had a protectable interest to defend their arrangement. The court did not go so far as to determine what that interest was, but it said it was protectable. The counties could do it. In the end, the land had to be returned to production. Fast forward to 2005. In 2005, the Oregon legislature determined that $10 million in the fund maintained by the Board of Forestry for these purposes should be used by the legislature for other budget needs. And the appropriation was characterized as a raid on the Board of Forestry funds. The county sued again, this time in Tillamook County. Judge Barron, in what is called Tillamook 2, ruled that not only was this a protectable arrangement, but it was a contract, plain and simple, by virtue of the deeds and the statutes that the deeds responded to, and ordered that the state of Oregon return the $10 million, which the state of Oregon, in fact, did. The state of Oregon's appeal of that ruling was unsuccessful. We believe that a legal doctrine called issue preclusion now prevents the state of Oregon from denying that there is a contract. That's obviously something that will be highly litigated, but it is our position that the state of Oregon and the Board of Forestry is stuck with the ruling in Tillamook 2, which, by the way, is a correct ruling. So let's skip back to 1998. In 1998, the Board of Forestry adopted a rule called the GPV rule, Greatest Permanent Value Rule. The Board of Forestry decided to fill the gap and define this previously undefined phrase to include not only economic returns, but ecological returns, recreational interests, aesthetic interests, and the like. The State Board of Forestry then and the Department of Forestry then implemented by 2000 a management regime which was responsive to their new GPV rule. We believe that over time a delta has developed, a difference between what these lands could produce if they were managed as a private landowner would do, who had to adhere to the Forest Practices Act, all the federal overlays, the Endangered Species Act, and the like, versus the production that is occurring because of the GPV rule, which underutilizes the property economically. That delta, we believe, through reference to the state's own models, is approximately $35 million a year. All right. So we believe that since 2000 at least, these counties have been deprived of $35 million a year, which otherwise would have been theirs had the state been managing these timberlands as a landowner should, complying with all the overlays, Forest Practices Act, Endangered Species Act, and the like. A couple other interesting points. Because this is a breach of contract action, the only limitation on the ability of the counties to claw back past damages would be the statute of limitations. Some of you may know that the statute of limitations in a contract action limits how long you can go back once there's been a breach of the contract. The statute of limitations is not applicable or assertable against government when government is suing. And you know what? That applies even when government is suing government. And so, because the statute of limitations for contract actions is not applicable, we believe we can go back to the time of the breach, to any damages since 1998. We believe those damages actually started to accrue in 2000. Once the management plans were put in place that responded to the GPV rule. So if you could turn to page 7 of the letter, We summarize what the damages are. We believe there is a damages delta of $35.24 million per year from 2001. That is a total of $528,600,000. We believe the class would also be entitled to prejudgment interest on the damages delta of approximately $25,564,000. And then we come to future damages. If the state does not change the management regime and decides to continue to move forward, and by the way, the courts have been very clear that the state has the ability to breach a contract so long as it pays damages. The state has a choice. It can be in default and breach a contract, or it can follow through with the contract, but if it breaches, it must pay damages. What is the value of $35.24 million in perpetuity? We believe that the net present value of that revenue stream is approximately $881 million. You add all of those together, which is how we get to the $1.4 billion claim. The other document, and finally on page 8, we have to, by rule, provide an opportunity to cure. And the state, we believe at this point, has two choices: either pay all of the damages or an amount that is negotiated that satisfies the class, which are the counties and all these local districts, or pay the past damages and change the rules moving forward to manage these lands in accordance with what the expectations of the parties were to their contract, giving them the benefit of the bargain. Okay, the final thing I want to cover with you, and I appreciate your patience in this briefing, are the charts that appear at the, let me see, they're the 6th and 7th page of your packet. The first chart is entitled Historic County Revenues from Forest Trust Lands and Annual Foregone Revenue. It lists the 15 Forest Trust Land counties. The second column shows the amounts they've actually received from this arrangement from 2001 through 2014. The next column shows their percentage of the total distribution that they're entitled to. The next shows their average annual distribution. On average, how much have each of these counties received per year? For instance, Linn County has on average received $3,120,000 per year from the arrangement. And then the final one is how much have they left on the table because the state has not provided them the benefit of their bargain per year. In the case of Linn County, that's $2,385,188. In the case of Clatsop County, it's $12,024,000 per year left on the table. Now, those monies, again, don't go directly to the counties. They go to the counties for distribution. But in the case of Linn County, that $2 million is shared with local districts, schools, public safety, fire, EMTs, librarians, you name it. Those local districts that are within the Forest Trust Land borders are entitled to pieces of that. All of those local districts are desperately in need of funding, especially in the area of public safety. And all of them would be greatly benefited. In fact, lives would be vastly improved if these monies were provided to those districts, and if local residents were permitted to re-engage in the employment which they have lost that would be produced if the state were honoring the contract as the parties bargained. Final page, page 7, is just an example. It also shows the historic county revenues and projections from the lawsuit, assuming the total claimed amount was available for distribution. Now, that assumes a court would award the total amount. That assumes there would be no deductions. For instance, there wouldn't be expenses deducted, etc. But because there's no way of knowing what those would be right now, we're providing you this number as an example. On a $1.4 billion claim, Linn County would receive a lump sum of $97 million. Clatsop County, $489 million. Washington County, $209 million. All of which could be used and distributed among their local districts for sorely needed governmental services. This lawsuit is not just about, as Commissioner Nyquist said, is not just about fiscal policy. It's about recognizing that the citizens of rural Oregon have suffered greatly over the years. The legislature has the right to change our policies. The Board of Forestry has the right to change our policies. But unfortunately, those policies, there's a cost associated with the change of those policies, and those costs have been disproportionately been felt by each of the local districts in the Forest Trust land boundaries, by the counties, and by the citizens, who not only have been deprived of services that they otherwise could have had, but have also been deprived of employment opportunities. And one of the numbers that we can't estimate here are the social costs that have been produced by way of the loss of employment. Those social costs have been monumental. And so we are hoping that our pursuit of this lawsuit and the courage of the Linn County Commission will be the first step in improving the lives of many of our residents in rural Oregon. With that, I will conclude. We're available for questions. I can answer any technical questions. Commissioner Nyquist is available here to answer any policy questions. We also have a press availability for the Portland media in Portland today at 1, and you'll be able to reach Commissioner Nyquist or me on the phone throughout the day if any questions arise. So, Doug, how much time do we have for questions? As much as we want. So,
just to clarify, other than Linn County, have any of these other counties or local districts formally kind of signed on to this in any way?
As in any class action, the class action is commenced by a representative party. There is, at some point in the litigation, a motion to certify a class. Assuming we file our complaint in 30 days or thereafter, we will accompany it with a motion to certify the class. The court will then determine who are the class members. For instance, in the typical class action case, let's say it involves a product, and a representative plaintiff believes that the public has been overcharged for the product. And the representative plaintiff files the case. The court then determines who out there in society are members of the class. Once the class is confirmed, and again, we believe the class is the 15 Forest Trust land counties and all of the local districts that have an entitlement to those monies. So let's say there's 120 class members. Once that occurs, class members are given an option. They can go along for the ride and be the beneficiaries of whatever is produced in the class action, or they can opt out. If they opt out, they then preserve their rights to litigate if they want on their own, or to not litigate at all. We do not believe a county has the right to opt out on behalf of all of its local districts. We think that is a county by county, district by district, town by town decision. And so once the members of the class receive a notice from the court, they will then have this option, probably 60 days in which to decide whether to stay in or to opt out, and then they are along for the ride.
Have there been any discussions with these other groups, or are they just hearing about this today?
I am going to presume there have been general discussions and angst for years about the distribution formula and how the counties have been deprived of the revenues that they should be receiving. I don't think it's going to be any surprise to any person who runs a local district or a county that they have not been getting as much return from this arrangement as they should be. Okay. As far as the class action concept, no, I don't think most local governments are aware of that. This will probably be, for many of them, the first that they have heard of it. And of course, I want to applaud the Linn County Commissioners for taking this step in an effort to recover for all of rural Oregon.
Mr. DiLorenzo, is Lane County and Douglas and Coos involved in the class action as well?
Take a look at the chart. You would see the counties. I haven't listed the actual local districts, but yes,
Are they?
Benton, Clackamas, Clatsop, Columbia, Coos, Douglas, Josephine, Klamath, Lane, Lincoln, Lynn, Marion, Polk, Tillamook, and Washington will all have an opportunity to determine whether they want to go along for the ride or whether they'd like to opt out and make their own decisions. Other questions?
Any ideas as to why the state would put itself in this position?
Well, I think that's probably a question that's better answered by our commissioners, or not at all at this point, or by the state. I believe that the state has known for quite some time that there has been a very soft underbelly to their position. And I believe the Linn County Commissioners have found that soft underbelly and are willing to press their case to benefit the residents of rural Oregon.
What's your sense of whether this will be resolved in court or through negotiations? Is this going to go to trial or not?
A class action case, a math professor that I had years ago once told me, John, you're using the word problem the wrong way. A problem is like a math problem that has but one solution. What you're talking about are predicaments. A predicament has an unlimited number of ways to resolve it. Predicaments are resolved, problems are solved. Our view is this is a classic predicament. The methods of resolving a class action like this are as varied as the imagination and good faith of the people who come to the table.
How did you and Linn County come to have a relationship on this? Did they come to you to ask to do this work, or did someone come to them and say this is a problem, you'd be a good representative class action plaintiff?
Well, I have been following the development of Tillamook 1, Tillamook 2 for years. Years ago, I was involved in Governor Goldschmidt's attempt to restrict exports of raw logs. And the question arose back then as to whether restricting exports of raw logs would diminish production from the forest trust land counties and would therefore violate the arrangement. So, the issue has been, I've been no stranger to the issue. I've been following it with great interest for years and years and years. I've had contacts in the local government community and in industry. At the same time, again, there is, and maybe Commissioner Nyquist can address this, there has been an incredible amount of angst among the forest trust land counties as to how the counties have been treated by the Board of Forestry. And it was just one of those perfect storms where I think we all just came together. Roger, would you like to make any further comments about that?
I would just say that over time, especially during our budget process for me, it's become clear that something had to give. And I also need to recognize Commissioner Tucker. I didn't see you in the room, or you weren't here. Thank you as well for your activism, Linn County Commissioner Will Tucker. And so I would say over time amongst counties and folks following this issue, there's been a consensus that there needed to be a game changer. And I knew John. I don't know. I can't recall when or how we met up on this, but we're happy we did, and we're grateful for the representation.
Anything else? All right, well, thank you. Oh,
I'm sorry, quick question. And sorry to go back over something, but, I mean, are you basically saying that the state should cut down more trees on these forest lands? I mean, what should they have done?
They should manage these to the greatest permanent value. In some cases, that's likely yes. In other cases, maybe not. It depends on the lot and the property you're looking at. The greatest permanent value in the way of economic impact trumps the other considerations that they've put ahead of that at this time. And the other thing I want to say is greatest permanent value, it means permanent. It doesn't mean that there will be a mass falling aggressively of a majority of the forests. It's something that's sustainable over time, that will be there in perpetuity.
I mean, if you're saying that the state should have realized more revenues from this land, how do you get more revenues without cutting down trees?
You don't.
So, I mean, it seems like
That's
logically
good.
you're saying the state should cut down more trees.
Right. Over time, they should stick to the practice that was agreed to in the 30s and 40s.
How did you estimate the revenue that you're saying that counties have lost?
Through the modeling, people familiar with this issue and in the industry developed some modeling.
Did you have a certain firm that you hired for that?
No.
And I would also say that the modeling is in part from the state's own modeling. You know, the Board of Forestry will develop 30 or 40 different scenarios sometimes. I'm exaggerating, but multiple scenarios before they make decisions on which one they're going to pursue. And much of this modeling is borrowed from that. But again, you know, one of the issues, assuming this case is tried, it would be tried to a Linn County jury. The jury would have to make a number of decisions. Number one, was there a breach of contract? Because it would already be assumed that there was a contract because of the matter I've reviewed with you before. And number two, what's the amount of the breach? And the amount of the breach would probably be calculated through a war of expert witnesses who would testify, and the jury would then decide what is the amount of the breach, how much in damages should the state pay. This is our best estimate of what our claim is. Cases are settled, cases are tried. There's all kinds of disposition to modes of disposition to a case like this. But this is our starting point. All right, if there are no other questions, again, we'll have another availability at 1 o'clock in Portland, and I'm available, Commissioner Nyquist is available all day long. If you care to call us if a question pops up, and if our answer might be useful to your coverage.
Just want to thank you all for being here and your coverage of this important matter for us. Thank you.